Welcome to California Virtual Family Law Attorney with founder Linda Garrett.
Hello, everyone. Welcome to California Virtual Family Law Attorney with founder Linda Garrett. Linda has been practicing family law in California for over 20 years, and she's the founder of the law office of Linda C. Garrett, based in Solano County. She offers both traditional representation and family law legal coaching, helping clients across California navigate divorce, custody, and financial issues with clarity and confidence. My name's Sean O'Connor, and today Linda and I are talking about how child custody is actually decided in California. Linda's going to explain, what the law says, how judges evaluate cases, what parents need to understand about the process, and a whole bunch more. So, Linda, good to see you.
Hi, good morning, Sean. How are you?
I'm doing great. As we speak, it's Friday, and that's never a bad thing.
Never, ever.
Linda, a lot of jargon in this space, a lot of, words that need defining. There's an expression or phrase that I hear quite a bit, best interest of the child. Comes up a lot in custody cases. What does that actually mean under California law?
Ooh, that's a loaded question. You might, so just like we hear in criminal courts, they'll say beyond a reasonable doubt. It's a legal standard. And so in family law, it's kind of cruel, but the term best interest of the child is kind of where the family judge has to look at everything that's important and relevant to deciding the judge what is in the child's best interest. And that's important because that could be any number of things. Is mother a drunk? Is father an alcoholic? Does a child have special needs? What's the distance of the parties where they live? Are there any educational issues, disabilities? It's essentially the court is not limited to any factor they need to consider in the child's best interest. And sometimes we use for short phrasing, BIC. So any litigants might ever see that, they'll say, oh, but that's a legal standard. So I'm going to step a little ahead because lots and lots and lots. Oh, and lots of times I have parents telling, well, I want this because he did this to me. And that's the parent's best interest. And the courts will and have distinguished between what a parent wants versus what a child needs. And that's why the North Star is always going to be within the child's best interest.
Makes sense. Another sort of definition question, I guess, is, the difference between legal custody versus physical custody. How do the courts treat those differently?
Yes, well, there's a third one also, which gets bumbled up with those two words, and it's visitation. So as a family lawyer, I'll hear the term, oh, I have custody, 50-50. I'm like, And I tell people, well, it's kind of like going to a store that sells a lot of flour. Is it wheat flour, white flour, rice flour, gluten flour? It's like people think, well, yeah, I guess it does matter. And outside of court, it may not matter, but in court, it's huge. So legal custody is essentially the decision-making powers that a parent or parents have regarding the big ticket items. Where does the child live? What's their religion? Do we vaccinate? Do we change their sex? It's not what does Johnny eat for breakfast this morning. It's the big ticket items. And normally, if the parties are married, the default starts at joint. And if the parties are not married, it's a whole different enchilada. Beyonce says you should have put a ring on it. And the mother has sole legal when she gives birth. And that's important. Then we have physical custody, which is again confused with visitation. And custody, physical custody, it's essentially in simple terms, and I'm trying to simplify this for anyone watching, is the child's residence. Where do they primarily live as a home? What address are we using on the child's educational records, medical records? And again, we start with joint for married couples, but then that could change based on facts. So mom decides to leave husband and move to Mexico, Tulum, Mexico, to live with her new 18-year-old boyfriend named Joey. So factually, the child can't live in two different places. Then the third one, again, that always gets confused with custody is visitation. I always tell people put a V equal sign schedule. It's how we share
Yeah.
our time with the child. And I emphasize this because many people, if not most who call me, don't know these distinctions. And I'm trying to figure out, okay, so is it physical? Is it custody, visitation? But that's important. And that's a great question. Thank you, Sean.
There is nuance. I mean, that's
Oh,
that's
yes.
that's why we need you. And then of course things vary state to state. So, in California, um, does the state automatically favor one parent over the other when it comes to custody?
So let's just start with words matter and the word favor. Favor implies there's a bias, and that's not the case. We just go to what are our default laws. And the default laws are not about favoritism, it's just what is the law. And the bottom line is the default starts with as follows. If you guys are married, the moment somebody wants to get divorced, we're going to start at the default of joint physical, joint legal, joint 50-50 visitation. And then again, the default law, if the parties are not married, is sole legal to mom, sole physical to mom, and technically no visits to dad because there is no what we call presumed dad. We have at best what's called an alleged dad.
If one parent has historically been the primary caregiver, how does that affect the court's analysis?
Oh my geez, these are heavy hitter questions. That is very tricky, and here's why. Because we have a married couple, for example, where husband's working 9 to 5 as a doctor, and he comes home, and wife's the stay-at-home mom, and she took care of the children, did the this, the that, the everything. And now one of the parties wants to get divorced. And so mom's gonna say, I know this from experience, well, I should be the primary caregiver. I've done everything. Well, the courts don't see it that way because getting divorced, I don't know, it changes things and we now have to start adjusting to a new reality of life without being in the same household. So the courts sometimes well, not sometimes, many times, will always, 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 Sean, look to the facts of the case. Is a child 3 months old? Is a child 17 and a half? Do the parents live 2 blocks away from each other, and sometimes they do, or are they now separate counties or separate states? So the court's going to look at actual facts. But the fact that mom was the primary caregiver, bottom line, it's just a factor under the BIC. Again, that's the point. It's a factor. And of course, if mom just says that's the reason I should have sole physical, sole legal, and no visits to dad because he apparently cheating with his nurse, that's not going to happen. And the courts are going to say, sorry, mom, this is not about you. This is about what the children need. Dad is a great dad, even if he wasn't the best husband. And that happens all the time.
This is, I mean, that little shift to the dark side, but, allegations of domestic violence can play a role. I'm wondering how that impacts custody decisions in California.
Okay, so yes, domestic violence heavily impacts. If I use just one code in this podcast or any other podcast, it's Family Code 3044. That's a huge, heavy hitter because it creates a legal presumption of law that if one of the parties has committed and or either found guilty or there's a finding of domestic violence either against the parent and or the children, there's a default that says, okay, now we went from joint, mother, husband, wife, to now the victim, let's say husband, is the one who was abused. He will by default now get under this presumption, so physical, so legal. I say this because unfortunately, many people know this law and it's abused. So, oh, I want to divorce my husband and I want to have so physical, so legal of the kids. What should I do? Oh, I know. Let me accuse him of domestic violence. So, is it legitimate complaint? Absolutely. I have those legitimate cases, but I would say almost equally 50-50. I have many cases where it's the 30-44 thereafter.
Yeah, they're trying to game the system, so to speak.
Exactly. Let
Yeah.
me find another way. And I do actually today have two cases that I'm going to court on, which is just that. And thank goodness my clients have the Ring Central cameras, other witnesses, timestamps of phone calls. But now my innocent client has to spend time, money, effort to prove his innocence. We don't have a guilt or innocence in family court, but to prove that he didn't do these things because we know that's what mom's trying to do. So is it
Got it.
important? Yes. Legitimate? Yes. Um,
It can
strategize?
be abused.
Yes.
Adjacent to that, in terms of someone's manipulating the system and trying to get sole custody with, but doesn't really have grounds. There's conflict there probably. It's not the best relationship. Clearly, people are getting divorced, right? So I'm wondering what happens when parents, they just can't communicate without, butting heads. It's like, how does the court structure custody in high conflict situations?
As best they can. Let's put it that way. And each judge, from my experience of, I don't know, almost 25 years in 11 Bay Area counties and 14 courthouses and many,
Yeah.
many judge,
People have
they
different
do
approaches, right?
different approaches, different opinions. Because technically speaking, is the communication so bad that we've got to give sole legal to one parent. And that is huge. That's like a constitutional right to be a parent. So if you're taking that away from another parent, you better damn well have a really, really good reason. Oh, he's been convicted of being a pedophile. That's a good reason. Oh, he's incarcerated for the next 6 months to 10 years. That's another good reason. But statistically speaking, I've seen judges kind of ignore the bickering. That's almost like the normal where people say, well, I can't talk with him. Is he a horrible person? Is he, he goes, no, he's just, I have no patience with him. That alone is not enough. It's got to be heavy hitters for the court to change it from joint, if it's already that, by law or by court order, to one parent. So
Yeah,
it's got to
that
be
makes sense.
big, huge.
Yeah. Yeah,
Hmm.
I can imagine. I mean, again, it's like, hello, you're getting a divorce. Yeah. I mean,
Duh,
you could
right?
guess they probably don't get along, right? And then,
Yes, right.
oh, I hate when he and I hate when she, and then that of course
Yeah,
carries into the courtroom, and it's like, yeah, yeah, yeah,
yeah. Yep.
not my problem, says the judge. Let's look at
Yes.
the.
Oh, let's not forget the burnt out fried judge who hears this every hour of every
Oh my
day.
God. Yeah, yeah.
Yeah. Yeah,
Pro
that's
tip:
another conversation.
try to get an early court time. I'm wondering about, we had talked earlier about best interest of the child. And if a parent believes that the other parent is not acting in the child's best interest, what kind of evidence? Because again, it's not, it isn't just like, oh, he lets them have too many cookies. This is more like, the parent is not acting in the best interest of the child. What kind of evidence does the court actually expect to see? Like what sorts of documentation are we talking about here?
Excellent question. But for me, from my experience, and yes, that includes me being jaded and skeptical, because you can't not be after all these years, is there are parents, shocker, that lie to me and to the court and say, oh, Miss Garrett, my husband's an alcoholic and he's a this and he's a that. I say, great. What's your evidence? What do you mean? Like, does he have a DUI? Can we look it up on the court's website?
Yeah.
Oh, no, not that. Do you have pictures you took while he's passed out on the couch with the 20 beer cans? No, I don't. And so the court sees it as well. The court every day is the he said, she said, or the two parties, the party A, party B, because it's same sex couples as well. Evidence is everything because other than evidence, it's an allegation. It's not a fact. For me, as I tell my clients, it's not a fact until you give me the proof. Otherwise, it's an allegation of abuse. It's this, but prove it to me because I
Yeah.
have learned from my experience. Again, shocker, people lie to me and the court.
Yeah. Surprise, people lie.
Surprise. Yep.
Um,
To answer your question, so that would include texts, photographs, emails, social media posts of pictures on Instagram, Facebook, anything else, anything literally that documents and that you can authenticate in court, meaning this is a true copy, because then we get the fakes on the evidence. Thanks to Adobe Pro, we can change an email that says yes to no. So, but at the end of the day, it's pretty much anything that's relevant and that is authentic, because that's a whole different enchilada at trial.
Yeah. Well, and there may, of course, actual eyewitness accounts.
Oh,
So,
and witnesses. Oh, right.
hey,
Live people too.
you know,
They count too.
right?
Yes. Yes.
I live next door to that guy, and I see him. He leaves the kid out in the backyard when it's raining. Whatever. I don't want to
No,
paint
keep
ugly
going.
pictures,
Keep
but
going. No, that
yeah,
does happen. I just
yeah.
if I have a funny story, but not so funny. I just found, and no judgment from the audience, please. Are you
Mhm.
Sean? But The Bachelorette, some woman from Mormon Wives is being canceled because there's some video of her, hitting and abusing the father of her child, and then somehow throwing stools at him. And I think that one of the stools hits their child,
Go.
you know? And
Yeah.
then she has a post from her PR people that say, "You're not seeing my side of the story. There's relevant background." Like, how can you justify what we're seeing, which is throwing things at him? The child's right there throwing
Hey,
things.
listen. Look,
Just,
we
she's the
we throw
victim here.
stools. Look, our family throw. It's our love language.
Yes.
Stool throwing.
Still throwing. But in the
That's it.
video, so in this apology, she's being the victim of the situation. And I'm like, and again, that's the thing. We see things behind us. So in court, I promise you, she's going to say, "Oh, Your Honor, I'm the victim of domestic violence and abuse, and he's a narcissist." I hear that so often.
Yeah.
And then he's
Yeah.
going
Yeah.
to present the video that
Right.
shows. And I've had that happen. And I provided those types of evidence to the court when the wife's saying to my client, the husband, "Oh, Your Honor, he's the abuser. He's the this." And God help her, because now she's lost her credibility with the judge forever.
Yeah. You've seen it all.
Yeah.
Uh, Listen, Linda, great talking to you as usual. We're out
Oh,
of
thank
time,
you.
which
Oh,
happens, but there'll be more
yes.
later, I'm sure. Have a great day.
Thank you. And it's a pleasure being on the podcast.
Thanks for listening to California Virtual Family Law Attorney with Linda Garrett. And if you'd like to learn more about Linda's family law legal coaching or her traditional representation services, visit the website lindacgarrettlaw.com. And if you found this episode helpful, please be sure to like, subscribe, or leave a review so others navigating family law in California can find reliable information and support. I'm Sean O'Connor. Thanks for tuning in. Have a great day.
Bye, everyone.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.